Hi, this is Reverend Bill Banuchi from the New York State Faith and Freedom Coalition, and I want to welcome you to this lesson 4 in our study of the New York State Constitution. Our fellowship, we actually call ourselves America by Faith. We are a Fear Not Fellowship. Our goal is to reclaim America in 2026. And we meet twice a month here in Newburgh, New York, on the second and fourth Saturday of each month for our WISP meetings. WISP stands for Worship, Information, Strategy, and Prayer. And we certainly invite you to come and join us as we work together to see America come back to God. Every year we look to God for a new word. This year for 2026, the word was raise the standard. That's taken from the book of Isaiah 59:19 that says, when the enemy shall come in like a flood, the Spirit of the Lord shall lift up a standard against him. And we're encouraging everyone to see how you can raise the standard, first of all, in your own personal life, in your spiritual life. Whatever God is calling you to do, push that barrier, and whatever God is calling you to do that you've been reluctant about doing it, go ahead and do it this year. Raise the standard. Be a little bit more like Christ than you were last year. And we want to raise the standard in our personal lives, in our family, in our community, and in our state, in New York State, and even in our nation. We want to see this standard raised up. So that's our word for the new year, is to raise the standard. And we're going to be looking, like I said, this is our Rebuilding Liberty program. Part 2, Part 1 was during the fall of 2025. Part 2 is during the spring of 2026. As we prepare for July 4th celebration of the 250th anniversary of the Declaration of Independence, we're gearing up for that, and we're looking forward to being equipped to see America bless God once again. So let's begin today with taking a look at, we've looked at some of the primary authors of the New York State Constitution. And we said there were 3 primary authors, John Jay, Gouverneur Morris. We looked at these 2 in the previous 2 sessions. And today we're going to take a look at Robert Livingston. So let's take a look at Robert Livingston.
Hi Founder fans, Jason here, and today's founder is Robert Livingston, the Chancellor. Now, I'm a little bit surprised I haven't spoken about Robert Livingston yet because he was so significant to the Revolution and to New York itself and to the United States, as we will get to. So, I do want to mention I have spoken about several members of the Livingston family because the Livingston family was a large family that was very important to the American Revolution. But as for Robert himself, he was named after several generations of Robert Livingstons in the Livingston family history, but he was still just 29 when he was sent to the Second Continental Congress. He had always been a bit louder than many other people when it came to anger at the king in Parliament, but when he was sent to the Second Continental Congress, he became an early advocate for independence. In fact, when the committee was created to draft a Declaration of Independence, that committee had 5 people on it. The other 4 all would sign the Declaration of Independence. John Adams, Thomas Jefferson, Ben Franklin, and Roger Sherman. Robert Livingston, who was also on that committee and there for the vote to become independent in July of 1776, he was recalled over the summer before the document was actually signed, so he did not get his signature on there, though his cousin Philip did, so it's fine. But Robert was called back to New York State because they had to write a new constitution. And Robert Livingston helped write that new constitution. And when that constitution was created, Robert Livingston was chosen as the first chancellor of New York State. Now, chancellor is a position that no longer exists in New York State, so it's a little bit hard to describe exactly. But essentially there was a chancellor, court of chancery, and a Supreme Court in New York. The Court of Chancery focused more on equity matters, which, for lack of a better term, is financial matters, and the Supreme Court was essentially everything else. However, the Court of Chancery was also the highest appellate court, so if something went to the Supreme Court and someone wanted to appeal it, it would go to the Court of Chancery. And Robert Livingston, as the chairman of the Court of Chancery, or the Chancellor, was in charge of overseeing these. And he held this position for 25 years, from 24 years technically, but a quarter of a century, from 1777 until 1781. during which both New York and the United States were formed. Now, he did spend about a year and a half during this time concurrently serving as Minister Secretary to Foreign Affairs for the Continental Congress under the Articles of Confederation. He was the first Secretary of Foreign Affairs in the history of the United States. Now, a few years later, the Constitution is written, and George Washington becomes president and goes to New York City, where the first capital was. And Robert Livingston, living in New York City, was the one who administered the oath of office to George Washington when he first took over as the first president of the United States. Such was the weight of Robert Livingston's respect that was held among the community in his state and others. Now, by this time, Robert Livingston was essentially known as the Chancellor. In fact, he would be, his entire life, would be called Chancellor Livingston. But Chancellor Livingston, when he resigned as Chancellor in 1801, he was immediately appointed by, at this point, President Thomas Jefferson, who he, helped write the Declaration with 25 years beforehand. Thomas Jefferson appointed Robert Livingston to go to France as a minister to France, and he did. And while he was there, he worked with not so famous quite yet James Monroe to, negotiate the Louisiana Purchase. And he's the one who organized and oversaw the treaty that doubled the size of the United States. And he does have a famous quote I want to read to you. It's a pretty famous quote from that day, where after he signed that treaty, he said, "We have lived long, but this is the noblest work of our whole lives. The United States takes rank this day among the first powers of the world." And it really was a far-seeing statement, because, the fact that the United States would grow so large so quickly definitely would help over the course of its history bring it up as one of the foremost powers in the entire world. Livingston wasn't done yet, though. Oh, no. Livingston, while he was in France, became friends with a man named Robert Fulton. And he and Fulton got along swimmingly, and Fulton was creating a steam-powered boat. A steamboat. And when the two men came back to the United States, Robert Livingston funded the first steamboats built in the United States. And the first boat, its maiden voyage, was from New York to Albany. And right in the middle of New York and Albany, on the Hudson, was a house called Claremont that was owned by who else? Robert Livingston. And his home became the first home port of a steamboat in North America. And just to put some perspective, the steamboat on its maiden voyage was able to travel from New York City to Albany in about 2.5 days. And this is reduced from 6 days. That might not sound like a lot when you can drive from New York to Albany in about 2.5 hours nowadays, but at the time this was an amazing change of time to get from one place to another. And because of this, both Livingston and Fulton joined the original board of the Erie Canal Commission, and they helped start the digging for the Erie Canal, because now that they had the steamboats, this was a viable option. Erie Canal comes along, and suddenly farmers growing crops in the Midwest can get those crops to the Great Lakes straight across New York, straight down the Hudson to New York City, where it can be traded around the world. And this is what made New York City, which was already one of the bigger cities in the young nation, and was quickly becoming a very important port on the world stage. This gave New York City access to a humongous variety of crops that would be sold worldwide, with the Erie Canal and Hudson River becoming essentially the first superhighway in the United States, with both people going out and products coming back. And because of this work, New York City became what it is today, and because New York City becoming such an economic powerhouse, it helped the United States become a powerhouse. So Robert Livingston not only helped create the United States, but he helped actually build it as an economic superpower. So I hope you enjoyed this video. It's a little bit longer than most of my videos, but Robert Livingston is an essential American revolutionary, and I can't believe it took me almost a year to make a video about him. So thank you for watching. Make sure you hit like and subscribe, because there are lots of random founders I talk about a lot also, and that's what took me so long getting to Robert Livingston. Thank you again for watching, and I will be back with another founder tomorrow.
Okay, well, that was a little bit about Robert Livingston. If you want to see some videos about John Jay and Gouverneur Morris, you can check them out on our previous YouTubes as well. All right, so now let's take a look at the New York State Constitution. Actually, today we're going to begin to get into the very meat of the Constitution, beginning with Article 1. And before we do that, let's just again remember what the preamble to the New York State Constitution actually said and tells us what it's all about. And it says, "We, the people of the state of New York, grateful to Almighty God for our freedom, in order to secure its blessings, do establish this Constitution." So for all those who claim a separation of church and state, you've got to remind them that even our Constitution the purpose of it was to secure the blessings of freedom that were given to us by Almighty God. So if you take God out of the equation, you have no government, because that is the very basis of our New York State Constitution and, in fact, our federal Constitution. So just remember the preamble to the New York State Constitution. It's very brief, very succinct, but it's very clear. We, the people of the state of New York, grateful to Almighty God for our freedom, in order to secure its blessings, do establish this Constitution. Okay, so let's take a look at this now. Article 1, Section 1 of the New York State Constitution states, quote, "No member of this state shall be disenfranchised or deprived of any of the rights or privileges secured to any citizen thereof, unless by the law of the land and the judgment of his peers." Now, what does it mean in plain English? This section guarantees due process of law. It means the government cannot take away your rights or privileges. Now remember, the whole purpose of the Constitution is not to not to give the government powers, but it's to restrict the government from restricting the powers of the people. The rights are given to us by God, and the purpose of government is to restrict the government, not to restrict the people. So the government cannot take away your rights or privileges unless it follows established laws, which we call the law of the land, or there is a lawful court decision, judgment of his peers, meaning a jury, verdict, or court rulings. In other words, the government cannot take away your rights arbitrarily. Key ideas is protection against arbitrary government action. The state cannot punish, imprison, fine, or strip someone of rights without proper legal procedures. We all have the right to a legal process. If the government wants to act against someone, it must follow existing laws, it must provide fair procedures, and it must allow access to the courts. Now, all of these things can be somewhat subjective. For example, what is a fair procedure? That's why we have the courts. You must have access to the courts in New York. Why is it important? This section is similar to the Due Process Clause in the U.S. Federal Constitution. It protects fundamental fairness and prevents the state government from acting unfairly or without legal authority. Now, here's how New York courts have interpreted Article 1, Section 1 of the state constitution over time. It guarantees due process, sometimes more strongly than the U.S. Constitution. Now remember, we said that the state constitutions were actually written 11 years before the federal constitution. And the federal constitution is just a broad talk about our rights. It's the floor, not the ceiling of government action. The state constitutions are the one that deal more with the day-to-day action. So the federal constitution can give you a certain level of protection, but the states can go beyond that. The New York courts treat Article 1, Section 1 as a state's due process clause. While it's similar to the federal due process clause, the New York Court of Appeals, now remember, in New York, the highest court in New York State is not the Supreme Court. It's the Court of Appeals. Don't ask me why. But for somehow New York always tends to get things backwards. So in New York, the highest court is the Court of Appeals, not the Supreme Court. But the highest court of appeals has said that the state constitution can provide broader protections than the U.S. Constitution. That means even if something passes federal constitution review, it could still violate the New York's constitution. So now let's take a look at this. In this case, a garageman sold a customer's car to satisfy a storage lien under New York's lien law. This is the case of Sharak versus Del Buick and Cadillac Incorporated. The statute allowed the sale without prior notice or hearing for the owner of the vehicle. Okay, so now the dealer uh, he sold the customer's car that was in storage. He never gave the customer notice about it. He just sold the car, and he claimed that he had every legal right to do that. So the question is, did this procedure violate due process? Under the federal constitution, the U.S. Supreme Court had generally required, quote, state action for the 14th Amendment's due process clause to apply. The garageman argued that the sale was a private action authorized by the New York State statute law, not sufficient state action to trigger federal due process. So he was saying this isn't about government restricting the rights of anybody. It's a private deal. It's a private transaction. The New York State Court of Appeals New York held that the statute violated the due process clause of the New York Constitution. Importantly, the court said it interpreted the New York's Constitution due process clause more broadly than the federal due process clause, found that the statutory authorization itself was enough governmental involvement to require procedural protections, required notice and opportunity to be heard before the deprivation of property. So what he's saying is that because it was the lien law, because he was trying to follow the lien law of New York State, the Court of Appeals said that itself was unconstitutional because there was government action. The lien law itself symbolized the government action. So because of that, it came under the due process. So he had to give the customer adequate notice. In that case, the customer won the case. The courts used this section to block laws of government activities that are arbitrary, unreasonable, not properly enacted, or lacking fair procedures. Again, it could be subjective. What is a fair procedure? That has to be determined by the courts. If the government deprives someone of property, employment, liberty, or certain benefits, it must provide notice, a fair opportunity to be heard, and a lawful basis. And that's what the automobile owner didn't have, and that's why he won the case there as well. All right, public employment and property rights. New York courts have used Article 1, Section 1 to protect tenured public employees from being fired without hearings, professional licenses from being revoked without due process, and certain property interests from unfair government interference. For example, once someone has a legal entitlement like a tenure or a license, the state cannot take it away without proper procedure. Again, remember, the whole purpose of the government, of the Constitution, is to protect the citizens, to protect their rights from tyranny of government action. It is the law of the land. This is more than just any law. The phrase law of the land has been interpreted to mean a properly enacted statute that meets constitutional standards. Again, the lien law in New York was determined it did not meet constitutional standards and is not fundamentally unfair. It must be fundamentally fair. So the legislature can't simply pass a law that strips rights arbitrarily. Courts can strike it down, and they have stricken laws like that down. When we talk about the phrase judgment of peers, historically refers to trial by jury. Courts interpret this as reinforcing procedural fairness in criminal matters. You are entitled to judgment of your peers, and that is a trial. Bottom line, Article 1, Section 1 is a powerful safeguard in New York. It prevents arbitrary government action. It requires fair procedures. It protects liberty and property rights. It allows New York courts to provide protection beyond federal minimum standards. However, it cannot supersede federal law. That's really important principle to understand. So the New York Constitution can give more protections than the federal Constitution, but it cannot supersede the federal Constitution. Okay, so now let's look briefly at Article 1, Section 2, and we're going to go through these quite briefly because uh, Article 1 is probably the most important part of the New York State Constitution. It is, in fact, the Bill of Rights of the New York State Constitution. If you recall, the Bill of Rights to our federal Constitution was added as an amendment to the Constitution at the end. New York was written 11 years before that. It was at the very beginning of the Constitution, and in fact, many of the federal Constitution based many of its own language based on the state constitutions. Remember, the state constitutions came first. So in Article 1, Section 2, the Constitution of the State of New York, you have the right to trial by jury. The exact text, quote, the trial by jury in all cases in which it has heretofore been guaranteed by constitutional provision shall remain inviolate forever. This section then addresses jury size and verdict rules. In plain English, Article 1, Section 2 protects the right of trial by jury in New York. It guarantees that first, if you had the right to a jury trial under earlier constitutional law, remember earlier than 1777, that right would continue. The right cannot be taken away by ordinary legislation. Criminal defendants are entitled to a jury trial in serious offenses. Civil litigants retain jury rights in traditional common law cases. Inviolate forever means the right is strongly protected and cannot be casually limited. Article 1, Section 2 protects the rights of trial by jury. In substance, it says that the right to trial by jury shall remain inviolate, meaning it must not be violated. Jury trial rights apply in cases where they are historically existed. In criminal cases, a jury consists of 12 people. In civil cases, the legislature may allow juries of fewer than 12, which New York does. Civil juries are typically 6 people. The right to trial by jury may be waived in civil cases if both parties agree. A defendant in a non-capital criminal case may waive a jury trial, and then that would be replaced by what we call a bench trial, a trial by a judge, but only in a manner prescribed by law. Article 1, Section 3 protects religious freedom. In substance, it guarantees the free exercise and enjoyment of religious profession and worship without discrimination or preference. No person can be rendered incompetent as a witness because of their religious beliefs. No one can be required to attend or support a place of worship. And the right does not excuse acts that threaten the peace or safety of the people. Now, this can be questionable with certain religions. A religion that, let's say, has certain practices that endanger the public, that is unconstitutional. So even the freedom of religion has its limits. So any religion that exercises things like, for example, wife abuse or anything like that, that would be unconstitutional under our U.S. Constitution. And in this case, any religion that does that is not consistent with our U.S. Constitution and our state constitutions as well. So we have to look at this, especially when we look at religions like Islam, which may very well come under that category. Okay, moving right along. Article 1, Section 4, habeas corpus. Quote, the privilege of the writ or order of habeas corpus shall not be suspended unless, in case of rebellion or invasion, the public safety requires it. This means it protects the privilege of habeas corpus, literally present the body. which is the right to challenge unlawful detention before a court. In other words, if you get imprisoned, you can't stay in prison without coming before the opportunity to come before a judge to plead your case. You can't just be held in prison forever. If the government decides just to leave you there until someday they decide to try you. Now, this was an issue with the January 6th people in Washington, D.C., where they held a lot of people in jail without ever giving them a day in court. They didn't give them the right. They have the right of habeas corpus, which means the right to present their body before a judge, and they didn't do that. The state can only suspend the privilege in extreme circumstances, specifically if there's a rebellion or invasion and public safety truly requires it, such as Abraham Lincoln did during the Civil War and at other times. Habeas corpus is an important legal check on government power. It ensures that if you are detained, a court must review whether the detention is lawful. So this prevents the government from just locking you up and throwing away the keys forever without you ever getting your chance to get before a judge. New York State Constitution, Article 1, Section 5. Excessive bail, fines, cruel and unusual punishment. In English, this section says that bail cannot be excessive. Courts cannot set bail higher than reasonably necessary to ensure that a person returns to court. Fines cannot be excessive. The government cannot impose disproportionately large monetary penalties. And 3, no cruel and unusual punishment. Punishments must not be barbaric, inhumane, or grossly disproportionate to the accused crime. In New York State Article 1, Section 6, you have the right to the accused due process. This section is one of the most important protections in the New York Bill of Rights. It covers criminal procedure and due process. We're going to talk about this here in a minute. Here's what it guarantees in plain English. No person can be deprived of life, liberty, or property without due process of law. That means that the government must follow fair procedures. You cannot be punished or detained arbitrarily. You are entitled to notice and a fair opportunity to be heard. What this means practically is that judges must set bail based on legal standards, not to punish someone before conviction. The state cannot use extreme financial penalties to effectively destroy someone's livelihood. Punishments must align with modern standards of decency and proportionality. Now, let's talk about an example. In February 2024, a New York trial judge imposed a civil fraud penalty totaling $454 million on Donald J. Trump for allegedly misrepresenting his net worth. To stay the enforcement of that judgment while appealing, the judge required Trump to post a bond of roughly the same amount, which functions similarly to a bail requirement in civil litigation. Now remember, the only difference between a bond and a bail is in criminal actions, a bond is in civil actions. So Trump's legal team argued that posting of a bond of that magnitude is practically impossible and unreasonable given the scale. An appellate court agreed to reduce the bond requirement. A New York appellate panel reduced the requirement appeal amount to $175 million and gave Trump additional time to secure it. This was effectively a reversal of the original amount required by the trial judge and his criminal bail determination, but a civil bond reconsideration. So we have to see there that judges themselves are restricted. They must be fair and they must abide to the state constitution themselves. So a person is given the grand jury protection. For felony charges, a person generally must be indicted by a grand jury before being limited, with exceptions to military cases, before a trial can begin. In other words, people of your peers have to agree that there's a reasonable chance that you did commit a crime before even the trial begins. So that's why an indictment is. An indictment is when your peers, a jury of your peers, gets together, they listen to the evidence of the prosecution, and they determine that, yes, there is a good probability that you committed a crime. Then, and only then, you can go to trial. The other thing that you're protected against is double jeopardy. You cannot be tried twice for the same offense after being acquitted or convicted. You're protected against self-incrimination. You cannot be forced to testify against yourself. This is the right to remain silent, as you probably heard so many times. You have the right to a speedy and a public trial. You have the right to a speedy trial, a public trial, and trial by jury. And let me tell you something, that is also very subjective, and in too many cases that you don't get a speedy trial under our Constitution, and we need to address that issue because too many people linger in jail just too long waiting for a trial to be heard. But by the Constitution, you have the right to a speedy trial. I guess the question is, what does speedy mean? Anyway, all right, moving right along. Article 1, Section 7. Private property cannot be taken without just compensation. If the government takes your property for public use, it must pay you fair market value. This is known as eminent domain. Public use typically includes things like roads, schools, public infrastructure, certain redevelopment projects. You have due process applied to taking of the property must follow legal procedures. You are entitled to notice, an opportunity to be heard, and a legal process to challenge the valuation of your property. This section also includes protections involving public lands, compensation procedures, specific rules for property appropriations. Now, how does it compare to federal law? Section 7 is similar to the taking clause of the Fifth Amendment of the U.S. Constitution. However, New York courts can interpret Section 7 independently and sometimes apply stricter procedures and protections, again, giving greater protections to the citizen than even the federal Constitution does. Why it matters? This section becomes important in cases involving government land seizures, infrastructure expansion, urban development, utility projects, and environmental or zoning disputes. Now, let's talk about the Kelo decision. This was an important matter. In Kelo versus the City of New London, that is in Connecticut, the Kelo decision was a 2005 U.S. Supreme Court case about eminent domain, the government's power to take private property for, quote, public use under the Fifth Amendment. The City of New London approved a redevelopment plan to revitalize its economy after economic decline. The plan involved taking private homes, transferring the land to a private developer, building offices, housing, and commercial space. However, Suzette Kelo refused to sell her home. She argued that the taking of her property to give it to another private property was not public use under the Fifth Amendment. The Supreme Court's ruling, 5-4, the court held that economic development can qualify as, quote, public use, even though the land would be transferred to private developers. The broader plan served a public purpose, economic growth, increased tax revenues, or job creation. So the court, again, there agreed that it was constitutional, but only by a 5-4 decision. This was very controversial. Many people were outraged because the property wasn't being taken for a road, school, or public building. It was being transferred to another private individual, a private party. Critics feared government could take homes and give them to wealthier developers. The decision was widely unpopular across the political spectrum, and since the Kelo decision, more than 40 states throughout the country have enacted laws to protect the individuals from this type of abuse. New York State, unfortunately, was not one of them. So we have to still be aware of that, and hopefully that Kelo decision will be reversed by a new, more conservative Supreme Court should it come up. The aftermath, many states passed laws limiting eminent domain for economic development. State constitutions were amended to provide stronger protections from the federal baseline. Constitutional principle, the case interpreted, quote, takings clause of the Fifth Amendment, nor shall private property be taken for public use without just compensation. The court interpreted public use broadly to mean public purpose, not just literal public ownership. So that's a really an important issue there. All right, moving right along. New York State Constitution, Article 1, Section 8. Section 8 of the New York State Constitution protects freedom of speech and freedom of the press at the state level. What it says in plain English guarantees that 1. Every person may freely speak, write, and publish their opinions on any subject. People are responsible for abusing that right, for example, through defamation or incitement. In other words, if you say something wrong to someone and they can sue you, and if what you did was not good, or you can pay the price. Yes, you have the freedom of speech. You also have the freedom to pay the consequences for your speech if you defame someone or cause someone harm in that way. So no law may be passed to restrain or abridge freedom of speech or of the press in New York. What that means is it functions similarly as the First Amendment of the U.S. Constitution, but applies specifically within New York. It protects individuals from government censorship. The government generally cannot punish someone simply for expressing opinions. However, speech is not unlimited. Laws against things like defamation, libel, slander, true threats, obscenity, under legal standards, and that's again a very subjective thing, and we need to come back to that. Incitement to imminent violence may still apply. So again, free speech has its limits, and even those, and many of them are subjective and can only be determined by the courts. But the courts is a function of the people as well. So we need to really talk about in the future days about what really is obscenity, and we need to restore decency to the whole culture. Anyway, that's another subject for another day. Article 1, Section 9 of the Constitution of the State of New York, a freedom of assembly and petition. Article 1, Section 4 of the State of New York Constitution protects the rights of people to gather and to petition the government. In plain English, it guarantees people have the right to assemble peacefully, meaning they can gather together for meetings, protests, rallies, or other group activities. People have the right to petition the government, meaning that they can formally petition the government to address grievances, change laws, or correct injustices. That's why you see petition movements throughout when issues come up. You want to sign those petitions, you want to get them to the government. Believe me, the government, the politicians are responsive to the voice of the people. So we need to be active in petitioning the government when we see them making wrong moves. All right. What this means is this section protects public protests and demonstrations, town hall meetings, organized political gatherings, signing and submitting petitions to the government officials. As long as assemblies are peaceful, the government cannot prohibit them simply because it disagrees with the message. Governments may impose reasonable restrictions concerning time, place, and manner of those protests and those assemblies. Public safety is an issue, and disorderly conduct or violence. These are not protected by the Constitution. Article 1, Section 9 says, this is an interesting one, that gambling is illegal in New York unless the Constitution specifically says it's allowed. And the Constitution now allows in New York State, state lotteries, quote, for educational funding, haha, charitable games, horse bet, horse racing bets, and licensed casinos. The reality is that the Constitution says that gambling is illegal in New York unless the government is involved and getting their share. So we need to address that as well. All right. New York State Constitution, Article 10. Article 1, Section 10 protects the rights of people accused of crimes. It focuses on criminal procedure protections. It was repealed and replaced by Section 6 that we already covered. All right, so now this was basically Article 1, the first 10 sections of Article 1 of the New York State Constitution. We will, at our next session, we'll cover the remaining 10 sections of it. But I just want to thank you for watching this video. Hopefully you learned something. We have a quiz sheet. If you want to send us an email, we'll be glad to send you the quiz sheet so you can answer it. And if you have any questions, feel free to shoot me an email at bill@nyfaithandfreedom.com. And hopefully we'll see you at the next time for lesson 5 on the New York State Constitution. Take care and God bless.